Okay, good morning, everybody. Let's get started. My name is David Goldstein. I'm the chair of the nonprofit tax exempt religious organizations practice group at the Certilman Balin law firm in East Meadow on Long Island. And welcome. Okay, so a couple of notes before we start. Of course, this presentation is not legal advice. Legal advice would require an attorney-client relationship. And in addition, it's not the opinion of my firm, Certilman, Balin, Adler, and Hyman. Rather, it's my opinion. And so on the subject of opinion, we're going to start with a focus on the current environment and the really truly unprecedented challenges that this environment poses for nonprofits. We've really not seen anything like it, and so we couldn't do a legal update without delving into this a bit. So that's where we'll start. So we see an environment that's chock full of threats, multiple threats. You've heard the term flooding the zone. And more than that, and we're going to spend a decent amount of time on this, I think, this morning. Some of these threats are existential, and I don't think that's a surprise if you've been following the news at all. And something that makes this different and unique is that this threat environment brings to bear the tremendous resources of the federal government. So let's talk about flooding the zone and some of the multiple threats for a moment. And here are just some examples. Threats to reduce future funding, threats to eliminate future funding, the possibility of reducing current funding or eliminating current funding. And accomplishing the foregoing could be done through legislative or administrative process, through executive orders, or by closing funding agencies or terminating specific programs or any combination of those and others. And then you've heard a lot about fraud, waste, and abuse, or fraud, waste, and inefficiency, sometimes in this PowerPoint using the abbreviation FWI. The Department of Government Efficiency, DOGE. DOGE, among other things, conducts audits and investigations. They are seeking to root out fraud, waste, abuse, fraud, waste, inefficiency. They're also looking at wrongdoing and violations, and so are other government agencies. And of course, if there are violations of law or wrongdoing, there are penalties. Whether there are violations of law or wrongdoing, just the audit or investigation in and of itself entails a very demanding and very significant process that, of course, and again, we're going to talk a little bit more about this, will occupy the resources of the nonprofit in a disproportionate way. And then, if all that wasn't enough, there's the nuclear option, which is what I'm terming it, which is the existential threat of a revocation of tax exemption. And that's been in the news an awful lot. And again, we're going to drill down a little bit on the legal standard there, which may be a little bit surprising when we get to it in terms of how readily that can be utilized. DOGE, fraud, waste, abuse, fraud, waste, inefficiency. There are investigations of fraud, waste, and inefficiency by DOGE. There have been instances of DOGE installing its own staff or representatives at nonprofits. In its most extreme form, this can amount to taking the reins of the nonprofit on a practical level. We should also note, and this is obviously very significant, that it's not only DOGE. There's the potential of investigations of nonprofits by federal agencies other than DOGE. These can be agencies providing the funding and or agencies alleging violations in their areas of regulatory responsibility or enforcement responsibility. So that tells us that the regulatory and enforcement possibilities available to the federal government are incredibly broad, whether it's DOGE or some combination of DOGE and other agencies. It's important to note that DOGE clearly has taken the lead initially, but other agencies may become more active over time. So something that jumps to the fore right away is the stark disparity of resources that we're looking at. There are so many federal agencies and organs. These agencies have the vast resources of the federal government at their disposal. And we should think about the practical impact of an investigation like this on a nonprofit. When you're the target, there's going to be a disproportionate impact on human resources at the nonprofit, at the leadership, staff, and board levels, on financial resources, on organizational focus, and on organizational resources and prospects. And, prospects, right? I mean, think about if you are the target of a investigation, something that may be in the press, what kind of chilling effect that will have on your fundraising, on your funding, and on your staff and prospects in all of those areas. Not to mention if you are the target of an effort to revoke your federal tax exemption. So let's come back a little bit later to a practical strategy as to how nonprofits can begin to address this disparity of resources. It's never going to be something that can be resolved, but perhaps there are some strategies that individual nonprofits in the sector in general can utilize to start to address the disparity. And we'll come back to that. So in terms of this disparity of resources, you've got the potential for some horribly unjust consequences. So if funds are withheld due to an ongoing investigation or due to a glitch in funding mechanisms, and that's happened, or alternatively, there could be efforts on the agency side to streamline or create efficiencies in the funding process or in funding procedures or in mechanisms of funding. And those efforts result in a temporary cessation of funding. So a glitch in the funding process, funding mechanisms, even if funding processes and mechanisms are streamlined as a result of this process and the funding is turned back on, or even if there's an investigation and there's no wrongdoing found and there's no fraud, waste, and abuse found. In the meantime, however, and the red font is not an accident. In the meantime, because the funding is temporarily shut off for any of the above reasons or others, the organization is forced to shut its doors due to the lack of funding. When the funding is turned back on, there's no organization left to fund. And this actually occurred in the case of a temporary glitch with the funding of some Head Start programs a few months ago. And we know of one Head Start program that was forced to permanently shut down before the funding stream was actually resumed. So this incredibly unjust and an inequitable set of consequences is something to keep in mind as kind of endemic to the structure that we're faced with here. Okay, so now let's turn to the nuclear option. And as I mentioned, that is revocation of tax exemption. Again, keep in mind the disparity of resources. When the IRS begins an investigation or an action to revoke an organization's tax exemption, it's you on one side and the IRS on the other, with all of the resources that the IRS has at its disposal. Remember also that we're talking not only about the loss of deductibility for donors' contributions, but also the exemption from income tax. Without tax exemption, an organization would be taxed as if it were a for-profit business. Translation, the organization would need to pay taxes on its income, among other things. And of course, note the potential chilling effect of such an investigation or enforcement action on funding agencies and also on donors. Obviously, if there was an effort to revoke or a decision to revoke an organization's tax exemption, donors would be faced with the prospect of not being able to deduct their contributions going forward. And again, that would also create issues for funding agencies as well. So I think this is something we should all really focus on, that there's a common misconception that it is extremely difficult to revoke an organization's tax exemption. In fact, the legal standard is shockingly and invitingly malleable. Here is the legal standard that the IRS can use. The presence of a single non-exempt purpose, if substantial in nature, will destroy the exemption regardless of the number or importance of truly exempt purposes. I'm going to read that again, and it may not be the last time that I read it, because it's so important and I think so surprisingly malleable. The presence of a single non-exempt purpose, if substantial in nature, will destroy the exemption regardless of the number or importance of the truly exempt purposes. And it's important to know that on the truly exempt purposes side of that equation, note the quantification. The number could be significant, and the importance could be significant, but yet a significant non-exempt purpose and substantial isn't defined in this standard. The significant translate substantial non-exempt purpose will destroy the exemption. So what court came up with this shockingly and invitingly malleable standard for revocation of tax-exempt status? You probably are sensing where this is heading, and that is the Supreme Court of the United States. This was a 1945 decision that has passed the test of time 80 years later. It's the Better Business Bureau of Washington, D.C. versus the United States, and that standard comes directly from that very significant and long-lasting Supreme Court decision. And it's been a standard that has been used consistently by the IRS and courts over the years in connection with revocation or potential revocation of tax exemption. So you've probably heard a lot about Harvard University in the news. And in addition to blocking almost $3 billion of federal funding for Harvard University, which coincidentally is America's oldest university, last month, President Trump suggested that Harvard's tax-exempt status should be revoked. In connection with that, the president stated, and this is a direct quote, "Tax-exempt status is a privilege. It's really a privilege, and it's been abused by a lot more than Harvard." So that's the end of the quote, but interpreting that a little bit, seems to me that President Trump was explicitly extending the threat of revocation of tax-exempt status to nonprofits beyond just Harvard. That's, again, not a surprise to anybody who's listening, but I think important to say out loud and recognize. It doesn't take, unfortunately, it does not take a great leap of imagination to come up with allegations that could fit into the Supreme Court standard for revocation of tax exemption. A single non-exempt purpose, if substantial in nature, will destroy the exemption regardless of the number or importance of truly exempt purposes. So, what about violating or assisting in the violation of immigration laws or regulations? That certainly could be interpreted to be a non-exempt purpose that's substantial in nature. And that, again, would destroy the exemption regardless of anything else that the organization might be doing. encouraging the creation of an environment that fosters racism, including through DEI initiatives or anti-Semitism, and we've seen that in the news as well. There's another potential single non-exempt purpose that could easily be construed as substantial in nature, destroying tax exemption. Teaching or disseminating information that is contrary to established facts or science. That could be something that's used in connection with certain environmental groups. And again, that's a single non-exempt purpose, substantial in nature. Engaging in impermissible political activity. That's a very broad and malleable category that's already being bandied about and used to target various nonprofits. Again, clearly could be argued to be substantial in nature and therefore able to destroy the tax exemption. And supporting enemies of the United States or designated terrorist groups. Again, this has been in the news a lot. It's actually in some pending congressional legislation. And again, a single non-exempt purpose that clearly would be viewed as substantial in nature. And so you could see this is just a quick partial list, and the possibilities are broad and pretty much limitless. So again, we need to come back to the disparity of resources when the IRS acts to revoke an organization's tax exemption. When that happens, the organization can challenge the revocation in court. But even if the organization is ultimately successful, the process can be prohibitively costly and prohibitively time-consuming. It can literally take years with multiple levels of appeal all the way up to the US Supreme Court. While Harvard University is up to this challenge, at least that's my take on it, because it happens to have a $53.2 billion endowment, the overwhelming majority of nonprofits clearly could not run this gauntlet, even if they ultimately could be successful on the merits. So you could kind of have a potential repeat of the Head Start scenario where the funding was ultimately turned back on, but the one Head Start agency closed its doors permanently in the interim. So in your supplementary materials, I think there are 5 items included, and 3 of them relate to the conversation that we're having now. So I want to talk a little bit about those, and one in particular. So the first, and again, this is available on the website, on the Cerini website for today's program. It's an opinion piece in the New York Times entitled, "Today, Harvard is the Target. Tomorrow, it could be your church," by Joshua Claiborne from about 10 days ago. Also, a news article in the Boston Globe entitled "The Bloodbath. Trump administration moves to terminate hundreds of federal grants at Harvard." That was from late last week. And then I gave you the full Supreme Court opinion from 1945, which I definitely commend to your reading. It's I think it's barely 4 pages long, so it's an easy read, pretty straightforward read, and I really encourage you to read it. A good thing to be familiar with. So I think we're going to talk a little bit about what I think is a very thought-provoking opinion piece in the Times by Joshua Claiborne. In that piece, Claiborne, who happens to be a noted lifelong conservative, makes a very compelling argument that I want to make sure to highlight for you. He argues that the conceptual and legal underpinnings to take these extreme actions have been present all along, but that our leaders have had the prudence not to make use of them because these same conceptual underpinnings can be just as easily used by or against one side of the or the other on the ideological spectrum. So, with a potential change of administration at some point, it could be in fact not universities, some of whom could be perceived as liberal and having a left leaning, but rather conservative houses of worship that could be the targets and that could lose their tax exemption for comments that might offend the sitting administration at a given point in time. And so let me read you a quote from the Claiborne opinion piece, and I really encourage everyone to read it. I think it's a very compelling and thought-provoking and eye-opening argument. So Claiborne writes, imagine a scenario. It's 2029, and a progressive Democrat sits in the Oval Office. Federal auditors descend on evangelical churches after pastors preach that marriage should only be between a man and a woman, labeling their words, quote, political advocacy. And remember, we talked about improperly engaging in political activities as one of the ways that exemption could be revoked. Synagogues face regulatory investigations for teachings on gender and sexuality that offend prevailing cultural orthodoxies. Faith-based charities, suddenly saddled with endless bureaucratic forms and invasive reporting requirements, find their missions suffocating beneath paperwork. Smaller congregations fold under legal expenses while larger institutions self-censor out of fear. Soon the pulpit is muted, faith leaders are intimidated into silence, and communities are stripped of their authentic voices. So again, I commend this entire opinion piece written by, again, a lifelong and noted conservative to everyone's reading. So where does this all leave us? We can wax philosophical or think about the implications for the future in keeping with the Claiborne opinion piece in the Times. But is there anything practical that we can do? So let's start with an external perspective. Let's look outside of our respective organizations. We've seen that industry-specific groups have been tremendously effective at providing organizations with intel and information, and even more importantly, at influencing the conversation and the thinking in Washington. And you've heard a lot about what I'm about to say now in the news, but because of the minuscule Republican majority in both the House of Representatives and the Senate, just a few elected officials can have a disproportionate impact on outcomes. We saw this demonstrated again just last Friday when the Republican-led House Budget Committee failed to advance the Republican budget bill, albeit temporarily. We also see this dynamic. We see it in a lot of places, but very prominently in the conversations and debate about state and local tax SALT caps, the SALT deduction, the limit on how much of a SALT deduction you can take. That's another area where a very small group of motivated Republicans is holding tremendous sway. So more than just intel and information, we've seen that industry-specific groups have been tremendously effective at lobbying and taking advantage of how influential a few voices and a few votes can be given the tiny Republican majorities in both houses of Congress. One very striking and informative example so far, because the state of affairs could certainly shift again, and we've certainly seen shifting winds consistently over these last few months. But so far, the funding of Head Start programs is somewhat eye-opening. Head Start was explicitly targeted for complete defunding and eradication in the Project 2025 blueprint associated with the Trump administration. And there had also been a prior attempt to target Head Start funding in the first Trump administration. Nonetheless, likely because of very effective lobbying of red state and red district Republicans whose constituents would have been greatly harmed if Head Start was eliminated, Head Start funding may yet survive. We're not sure, but it may yet survive. So one potential takeaway is that collective action by industry-specific groups can work. So back to addressing the stark disparity of resources, as we said, Harvard has the resources to take on an aggressive assault by the federal government, but precious few nonprofits have the resources of Harvard, so this disparity is really somewhat daunting and intimidating. However, through organizing and collective action, nonprofits can bring collective resources to bear to level the playing field so that individual nonprofits are not as isolated, not as vulnerable, not as overwhelmed by the disparity of resources. Industry-wide and sector-wide resources can be brought to bear to defend even a single nonprofit that's under attack. So let's shift to the internal perspective. We talked a little about an external lens, but let's shift internally for a moment. Looking inward, what steps can organizations take right now in an effort to prepare for potentially unpleasant possibilities? And that's obviously an understatement. And I think that the obvious step, and it's kind of screaming from the hilltops on a few different levels, on the practical level and on the legal fiduciary duty level, is contingency planning. Effective risk management, including contingency planning, is in fact part of every board member's and every officer's core fiduciary duty to the organization. There's something called, in New York, under New York nonprofit law, the duty of care, and it requires every board member to act in a way, and we might be able to have some time to delve a little bit more into it later, but if not, there's some information on it in your outline in this PowerPoint, which will be also available to all of you. And that includes a quote from Section 717 of the Not-for-Profit Corporation Law, where the duty of care is codified. And it basically requires every board member and every officer to act with a degree of care that an ordinarily prudent person would in a like circumstance. And in circumstances such as these, contingency planning would clearly be what a prudent board member or officer would do. And so it's part of every board member's fiduciary duty. And obviously, financial contingency planning is at the core of this. Unfortunately, a lot of my clients are spending a lot of time planning for what would happen if this grant or that grant or this funding stream or that funding stream were to cease, either temporarily or permanently. And planning that response is a critical piece of what organizations, staff, and board together need to be doing. Don't overlook external and internal communications, and don't overlook the requirement, and this is really critical, the requirement to fully inform and fully involve your board of directors, including in planning and decision-making. Important to note that this is not optional. It is mandatory and required. The board has fundamental and far-reaching oversight responsibilities, and for the board to be able to fulfill those, it needs to be informed and be involved in decision-making on an ongoing basis. So sometimes there could be the inclination to try to manage things in a small, tight-knit group of either senior staff or some combination of senior staff and board members. Efficiency is something that's very helpful at a moment like this, and there really needs to be an awareness to push back against that kind of approach, because we need to make sure that the board, the entire board, is A, fully informed, and B, fully involved in decision making, and that's a legal requirement. Using board committees can be very efficient and very effective, and Some of the committees that jump to mind are the executive committee, a finance committee, a governance committee, a crisis management committee, a communications committee. But make sure, as I said, to fully inform and fully involve the full board, as well as a responsible committee. When the board delegates authority to a committee under New York law, the board is not divesting itself of responsibility for those matters. So it's critical for the board to remain informed and engaged. Let's think about making sure not to make your organization an easy target. So imagine if I'm a staffer at DOGE or perhaps at the IRS or another regulatory agency. I might be on the lookout for easy targets, organizations that might fit the ideological bill. Maybe it's an immigration organization, maybe it's an organization with significant DEI activities and initiatives. Maybe it's an environmental organization. Again, the possibilities are endless. So my organization might fit from an ideological perspective, but perhaps there might be additional independent bases for regulatory attack and action. Perhaps there's another substantial, and this gets back to that Supreme Court standard from 1945, in the Better Business Bureau decision for the standard for revocation of exemption. Perhaps in addition to that ideological target, there's another substantial non-exempt purpose that I, as a DOGE or IRS staffer, can identify and target in addition to that core ideological target. So maybe there are governance irregularities or insufficiencies. Maybe there are insufficiencies in internal financial controls. All of those issues should be cleaned up urgently and cleaned up now. They should be cleaned up irrespective of DOGE and the current administration. In fact, they should have been cleaned up yesterday, but there is no better time than right now. And I've got something of a personal example here. We have a new client for whom we did an initial governance assessment. And in doing that governance assessment, we identified a substantial non-exempt purpose in addition to the ideological target that might attract DOGE or the IRS in the first place. And this additional substantial non-exempt purpose is being rectified by the organization right now, and as a result, will not be sitting there for adverse attention down the road. And so it's making this organization a less inviting target. We're not eliminating, were we not eliminating this substantial non-exempt purpose, its continued presence would make this organization a much easier and more inviting target for attack down the road. So that's really something to focus on. And did I mention, and if not, you certainly heard me mention it in the past, if you heard me speak before, the importance of doing a governance assessment. And again, independent of the times we're living in, but there's no time better than right now if you haven't done one recently. So I'm gonna transition from the current environment to some core governance cornerstones that I want to make sure that we as nonprofit organizations never lose track of. And some of this, and I don't know if we're going to get far enough in the PowerPoint, but if you finish it on your own, it's written kind of in outline form, so it's certainly digestible and understandable. If you read through it on your own, if we don't get through all of it this morning, and we won't, you'll see some fruit photos inserted, and I think a lot of what we've spoken about already, and certainly what we're about to speak about now for a few minutes, a lot of this is low-hanging fruit that the organization can get its arms around pretty readily. And if the organization doesn't, these are things that potential adversaries of the organization regulators, et cetera, could get their arms around at a later date. So one really fundamental requirement is that every New York nonprofit is required to have an annual meeting every year. That's what annual means. And two things have to happen at a minimum at every annual meeting, and they're critically important. Again, very straightforward, very simple, very low-hanging fruit. One is the election of board members. That can either be electing the entire board all at once, depending on what your bylaws require, or electing a class of the board. The board can be divided into classes, up to 5 classes, and one class would be elected each year. So there have to be annual elections for board members, number one. And the second thing that must happen at every annual meeting is the delivery of the annual report. The annual report is a critical touchstone of nonprofit governance in New York. There is information required by sections 519 and 513 of the Not-for-Profit Corporation Law. It is hardwired. It is in the statute. It must be delivered as part of the annual report, and that annual report must be included in the minutes of the meeting of the annual meeting. So again, very straightforward, but critical. A second cornerstone of governance to always keep in mind is New York's focus on conflicts of interest and related party transactions. New York has the most demanding conflicts of interest regime in the nation. This comes up all the time. It's used again by regulators, by private litigants, and it's something that is very much scrutinized by donors and funders. Very often donors and funders mine the information on an organization's 990 to try to get an understanding of how the organization approaches conflicts and related party transactions, and so that information is very easily accessible because the 990 is so ubiquitous and obviously publicly available. With respect to conflicts of interest, the adoption of a conflict of interest policy is required under New York law, but here's the kicker: it's not just any policy. So the IRS has a sample conflict of interest policy that's available for free on the IRS website. If you're a New York nonprofit and you're using that policy, you're breaching New York law in a multitude of ways because the New York legal requirement mandates that the policy contains certain required definitions that are not in the IRS policy, for example. There are required processes and procedures. There are literally what I term, not the statute, but what I term the magic words. So if you're approving a related party transaction, which itself is defined under the statute and must be defined in your policy, and the statutory definition must be incorporated. It's mandatory that that must be incorporated in your policy. If we're looking at a related party transaction, it's not enough to review it and approve it. The board must adopt the magic words in approving the related party transaction. It must make a affirmative determination, and these are the words in the statute, that the transaction is fair and reasonable and in the best interests of the corporation at the date hereof, of course, based on some objective information. And written disclosure is key to the New York conflicts of interest regime and approach. Written disclosure before joining the board, written disclosure at least annually, and here's again something that people lose track of, written disclosure on an ongoing basis. So if I submit my conflict of interest disclosure form this week and a conflict of interest arises 3 weeks from now, I need to submit a written disclosure with respect to that conflict 3 weeks from now, notwithstanding the fact that I've already submitted a disclosure form today. So number 3, in terms of cornerstones of nonprofit governance that we should always keep our eye on. corporate purposes. We always need to monitor our corporate activities against the purposes set forth in our certificate of incorporation. The legal principle here is a diversion from corporate purposes, no matter how worthy, is a fundamental breach of fiduciary duty. And it's what I describe as the certificate of incorporation trap, because the very first document that a corporation files in its corporate existence is the certificate of incorporation. And oftentimes a corporation files this document and then with the Department of State and then files it away and doesn't look at it again, and evolves to meet needs in its area of operation. And lo and behold, over time, we have departed from the four corners of the activities that are set forth in our certificate of incorporation, and that is impermissible. And it's one of the central oversight functions of board members and officers, is that the use of assets must remain consistent with the purposes set forth in the certificate of incorporation. Those purposes can be amended, but for charitable nonprofits, there's a process that includes Attorney General approval or court approval of the amendment of your corporate purposes. It can be something of a cumbersome process, but be that as it may, it's a required process. And the point here, the takeaway is that it's, again, a core part of fiduciary duty of board members and officers. And it's not only that board members and officers have fiduciary duties under the law, but in addition to that, there's potential personal liability for failure to strictly adhere to corporate purposes. And that comes sometimes as a very unpleasant surprise to particularly board members who tend to be volunteers, sometimes also tend to be donors. They can be quite surprised to find out that they can have potential personal liability for failing to adhere to their fiduciary duties, including making sure that corporate assets are used only for the purposes outlined in the certificate of incorporation. So something to be alert to here is it's a little bit risky to put your corporate purposes in your bylaws. I really discourage our clients from doing that. Bylaws are very easy to amend. You don't need to get Attorney General approval to amend the purposes in your bylaws. You don't need to file those bylaws with the Department of State the way you would with a certificate of incorporation amendment before it's effective. So it's a little too easy to amend those purposes. And if you put purposes in your bylaws, they may get amended over time, and your bylaws are something that people internally are looking at all the time, and it may cause confusion as to what your permissible purposes and activities are. Mission statements are also something to be careful about, because when you're developing and changing a mission statement, you need to measure that always against your corporate purposes. And it's a good idea, and this is where a governance committee comes in very handy. It's a good idea to have some internal lens, and again, that's a governance committee could be that lens that's focused on governance all the time. And included there is always measuring not just your mission statement, but your corporate activities. Look at the website, look at the budget, look at the program activities, and make sure that all of those fit neatly within your corporate purposes. And the metaphor I like to use is that the corporate purposes are basically a fence and a box, and the nonprofit's activities need to always fit within those purposes. And no matter how worthy activities may be, if they are outside of those purposes, they are without question a breach of fiduciary duty by everyone on the board and by all of the officers. So that's a good place to end. I want to emphasize that if you've got follow-up questions, I really encourage you to email me. My email address and my phone number are in the PowerPoint. So feel free to reach out. Love to talk with you and follow up on today's presentation. And I thank everyone for their attention and look forward to speaking with you and seeing you all sometime soon.